Are we ready to proceed? Okay. All right. Good afternoon and welcome to this online hearing of the Committee of Adjustment for the City of Ottawa. Committee of Adjustment is a quasi-judicial tribunal appointed by City Council to make decisions on certain types of applications under the Planning Act. My name is John Blatherwick and I'll be chairing the hearing today. With me are my fellow panel members, Bonnie Oak-Charon, Stan Wilder, Heather McLean, and Michael Wildman. Please take note that this video conference is being live streamed on YouTube. The video will be archived along with today's agenda on the city's website. Before we begin, we have a few items to outline for your information. While the issues surrounding the development in the city are broad, our mandate is quite limited. The committee cannot consider aspects of the proposal that are not related to the required variances, noise, pollution, property maintenance, property values, prosecution for illegal construction, personal comments regarding neighbors, agents, or applicants, and additional variances without proper public notice. If there is an identified need for an additional variance or variances, including an increase in the extent of the relief required, a recirculation of the application is required. As part of the statutory public notification requirements, each applicant was required to post a sign on the property and file a statutory declaration confirming the sign posting. And I'm looking at my list of speakers today, and we don't seem to have that requirement met. So I'll have to administer the oath or solemn declaration to agents and applicants before we can hear their application. Regarding quorum, if this is lost during the hearing due to technical difficulties, the proceedings will be paused to allow time for the resolution of the issue. Failing the ability to reinstate quorum, hearing of the items remaining will resume at the outset of the next regularly scheduled meeting of the committee. In terms of the hearing process, listed on the agenda and appearing on the screen are the applications we will hear today. For the sake of efficiency, the committee may deal with agenda items in a different order. Note that the committee members have reviewed the application materials prior to this hearing and any written submissions received in support or in opposition. In addition, the committee will hear today oral submissions from any interested parties as part of our proceedings. The committee may ask for a brief presentation by the application, followed by questions from the members where clarification may be needed. The public submissions portion of the hearing will then begin, and any interested parties will be invited to make their submissions to the committee. Panel members may then ask follow-up questions where additional clarification may be required. When you are called upon to provide your comments, we would ask you to do the following. Starting with your name, state your name, municipal address for the record. We may ask you to spell your name. Then begin your submission by addressing your comments to the panel members. You may ask questions, but please direct them only to the chair. Please limit your comments to a maximum of 5 minutes. Any exceptions will be at the committee's discretion. Once all interested parties have had an opportunity to address the panel, the public submissions portion of the hearing will then be closed. The committee will then make an oral decision to either grant or deny the application. The committee may also choose to reserve its decision. In such case, the panel will deliberate further on the evidence presented immediately following adjournment of the public hearing. In either case, the committee will send within 10 days of its decision and to all parties and those who have requested it, a written decision that sets out the reasons for the decision. All decisions of the committee are subject to a 20-day appeal period, during which the decision can be appealed to the Ontario Land Tribunal for a fee. Before we begin, are there any declarations of interest for any of the members regarding items on this agenda or the agendas of panel 2 or panel 3? No. Okay. We have minutes to confirm from October the 5th and October the 19th. Regarding the minutes of October the 5th, 2022, any amendments, comments? All in favor of the minutes as presented from October the 5th? The minutes are adopted. Regarding the minutes of the 19th of October, 2022, again, any amendments, questions, comments? All right. All in favor of adopting the minutes from the 19th of October as presented? All right. Those are adopted. Before we get on to the regular agenda, we have several requests for adjournment. The first request for adjournment is for item 1 on the agenda, And this is regarding 608 Tweedsmuir Avenue. And the application is to permit reduced interior side yard setbacks, front-facing garages, and increased building height for the construction of a two-story semi-detached dwelling. The adjournment request has come from Miss Shannon Kelly at 604 Tweedsmuir, who is the next door neighbor. And I'm wondering if she's online. Okay. Ms. Kelly requested the adjournment because she was concerned that the new build beside her house would reduce the natural light on her home. She was also concerned regarding snowfall in the driveway from a great height from the new build. And she's also concerned about parking with the addition of 2 more apartments in the basement. I believe the agent for this application is Ms. Hill.
Hello, my name is Ruth Vandergeest. I'm here on behalf of Rosalind J. Hill. Address is 414 Churchill Avenue North. Okay.
You're aware of the adjournment request?
Yes, I am.
Okay. And are you in agreement with the adjournment request or not?
We are in agreement and would like to post to adjourn to December 7th if possible.
December the 7th?
Yes.
Have you been in contact with the neighbor regarding the adjournment request?
I personally am not aware. I am aware that Rosalind has been, and we would like that time to consult further with the neighbor.
Okay. Because the members of the committee, we've heard that the applicant and the agent or the next door neighbor have spoken and agreed to an adjournment request to the 7th of December. Mr. Garnett, do we have sufficient space on the agenda on the 7th of December?
Mr. Chair, I believe there are 10 items on the agenda currently.
Okay.
So I'd leave it to the committee to determine whether we can accommodate an additional application.
Okay. Any comments from the members regarding this? All right. Well, it's normally our policy to Mr. Wildman.
Sorry, is the applicant's consultant in the absence of Ms. Hill? Is it your preference to wait because Ms. Hill is unavailable, or are you? If we were to ask you to present, would you?
I am unable to present on behalf of Rosalind Hill. She is also unable to attend today. She's caught that nasty cold that's going around. So.
Okay, well, that answers the question for me in terms of deferral. Thank you.
Okay. So we normally accede to a request for adjournment from either the applicant or neighbors when it's a reasonable request. And in this instance, it seems like they're both the applicant and the neighbor have been in discussion and have agreed to adjourn. And so as far as adjourning this application until December the 7th, our next hearing, all in favor? Okay, we'll adjourn that until December the 7th. We'll see you then.
Thank you very much.
You're welcome. Second item on the adjournment agenda is 623 Rowanwood. And this is an application to permit a reduced lot width, lot area, and total interior side yard setback and a front-facing garage for a 2-story detached dwelling. The existing dwelling is to be demolished. And I believe the adjournment request has come from the planning department. Ms. Planner there. Ms. Linker. Please articulate the department's request.
Thank you, Mr. Chair. Staff requests an adjournment to allow the applicant time to address the identified zoning noncompliance issues through either revised plans or through the addition of minor variances to the application.
Is it the department's position that there will be additional variances required?
We've identified a number of noncompliance issues, and it depends on a redesign of the building to accommodate the zoning bylaw.
Okay. And urgent sewer is or no, pardon me, wrong application. Ms. DeSanti, you're the agent for the applicant.
Yes, good afternoon, Chair and members of committee. And my client, Rahil, is also online, who's the landowner, and we have no objection to the adjournment request. In fact, we're trying to schedule a follow-up meeting with Ms. Linker to address some of the zoning matters and looking at redesign. We also acknowledge there was a public comment submitted as well. My client has been in discussions with the resident a few months ago, not since the recent email, but that will be followed up with as well. So we're kindly asking for an adjournment to the December 7th meeting, please.
Are there going to be additional variances required with this application?
So, Mr. Chair, I can't confirm at this time. We need to have this discussion with the city planner. I am aware that if there would be re-signing fee, et cetera. So we'll cross that. We'll address that. We're hoping to meet with Ms.
If
Lincoln.
there are further variances, we adjourn sine die. And my question to you is, can you have these issues resolved by Friday this week, because the notification on the next hearing goes out on Monday? Because if that's
Would the committee need the revised plans and applications by this Friday?
we need to know whether or not there are going to be additional variances required.
So, Mr. Chair, we can expedite the meeting with Ms. Linker and confirm. So this is a priority for us. So we would like to adjourn to December 7th if possible.
Not knowing whether or not there will be variances.
Well, there will be variances. I can't confirm right now if there will be additional variances than what we've submitted and applied for.
Mr. Wildman?
Just a word of advice maybe to the applicant. It may be in your interest to go sine die, because you may miss your window, and then if you're not there for the 7th, you've kind of lost your opportunity. Whereas if you go sine die and you happen to meet all the timelines, you may still be able to get on the 7th. So just a word of caution and also a word of advice. I think Mr. Garnett may wish to add something as well.
Thank you, Member Wildman, and through you, Mr. Chair. I just wanted to clarify on behalf of staff that we wouldn't be, staff wouldn't be able to recirculate for December 7th, even with confirmation by Friday. The mail out would be Monday, and we wouldn't be able to observe the process steps involved within a matter of a day.
Okay, so thank you for that. So, Mr. Chair, I think we'll go sine die, adjourn sine die, and I understand there's a January meeting, so we'll still prioritize the meeting with Ms. Linker and the project team's designer and with our client. Thank you.
Okay, thank you. So with that, all in favor of adjourning this application, sine die. Hopefully we'll see you in January.
Yes, you'll see me a little bit later in the meeting agenda. Thank you.
All right. Okay. Thank you very much. We'll now move to the rest of the agenda. The first item before us is agenda item 2, 52 Huron Avenue. And this is an application to permit a front-facing attached garage for a proposed detached dwelling. The existing dwelling is to be demolished. And I note that the planning department opposes this application. Our Mr. Sewer, I believe, is the agent for the applicant.
Yep, good afternoon.
Your address for the record, please, Mr. Sewer.
43 Echo Street, Unit C,
Okay.
Ottawa, Ontario.
I'll have to administer the oath. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly and visible and legible during the entirety of that time?
Yes, I swear.
Okay. So So very briefly, Mr. Sewer.
Yeah, we have some presentation slides. If you can have those up, please. Awesome, thanks. So good afternoon, Honorable Chair and members of the committee. My name is Urgent Sewer, and I'll be presenting our application for a minor variance at 52 Huron Avenue North. With me on the call today is my colleague Christine McQuaig and the property owners Ed and Sharon Bryant. And just to advise at the end of the presentation, I'd like to pass it over to the property owners to share a few words of their own. So if you go to the next slide. Actually, if we could move to slide 6, please, just for the sake of time.
Yeah.
So the proposed development is to construct a 2.5-story detached dwelling with a front-facing attached garage. The home is designed to align with all other zoning requirements, including front yard soft landscaping, and retains the existing streetscape tree on the site. Next slide. Next slide. And next slide, please. So one variance is requested to permit a front-facing attached garage where no front-facing attached garage is permitted according to the streetscape character analysis for the street. Next slide, please. So I'll now move into a discussion of the 4 tests, beginning with whether the variance is minor. So the variance is considered minor as the proposed garage will not alter the future dominant streetscape character group of Huron Avenue, even as there are many other front-facing attached garages nearby in the neighborhood that were just outside of the SCA scope. Next slide, please. So as you see in the image, there is precedent for attached garages in the immediate neighborhood, with some located right on Huron Avenue, and a few of which are even double garages. So the proposed garage would not be a design element then that's completely outside of the established character of the neighborhood, since it is an element that is featured in plenty of homes nearby in the neighborhood. Next slide, please. Additionally, the overall massing and design of the home is done to reduce visual emphasis on the garage, which is offset from the front entrance and the front porch. Elements such as the box bay window, material choices, and the large windows help break up the facade of the building and add visual interest, which helps integrate the garage into the overall design. The aggregate front yard soft landscape area ensures enough front yard space is also provided to soften the appearance of the home and allows for the streetscape tree to be retained. The proposed attached garage is also a superior design choice and is functionally superior to the permitted 1.8 meter cantilever option. Next slide, please. So this is a side-by-side comparison that shows the differences between the 2 designs. So as you see, the garage option is a more symmetrical and well-proportioned design. It integrates better into the overall facade and provides vehicle enclosure, which helps to secure a parked vehicle and ensures that a vehicle is not visible in front of the home. The garage also provides functional benefits that are unrelated to parking, including the ability to securely store household items, bikes, and the like, and to store refuse containers in a manner that does not impact the streetscape. This option also allows for the safe and efficient electric vehicle charging and is supported by neighboring residents. Next slide, please. So in that spirit, the map below shows the consultation that the property owners of this application. They spoke to 34 of their neighbors, of which 14 provided verbal support. Notably, the 2 abutting neighbors and the ones across the street at 49 and 53 Huron Avenue, all of whom would be most likely to be impacted by the development, indicated that they support the proposed development with the front-facing attached garage. Furthermore, as you would have seen, 2 written letters of support were received, including one from a neighbor on the same street at 80 Huron Avenue and another on neighboring Caroline Avenue at 65 Caroline Avenue. So based on these reasons, the variance should be considered minor. Next slide, please. So the variance also meets the intent of the official plan, which is to accommodate a full range of low-rise dwelling types within the general urban area and within low-rise residential areas in the secondary plan. It supports the continued residential use of the lot, provides a contextual ground-oriented dwelling form with similar massing to surrounding homes, and results in a attractively designed home that positively contributes to the streetscape. Next slide, please. So the variance also meets the intent of the zoning bylaw. So the intent of the streetscape character analysis provision is to ensure that the new development demonstrates good urban design that does not adversely impact the streetscape. The original basis of the SCA process was to prevent badly designed stunt garages that were out of context with the streetscape. The intent is not to prohibit the provision of garages and does not relate to parking, which is permitted here. It specifically relates to design. So this intent is met as the garage is designed to integrate into the overall facade of the building with a lot of the design elements that I talked about. The garage element option is therefore closer to the intent of the bylaw than the cantilever option, in addition to being functionally and aesthetically superior. Finally, the required, if I just may be permitted to continue a little bit more, we're almost done. So finally, the required aggregate front yard soft landscape area and the streetscape tree are retained, which further meets the zoning intent. Next slide, please. So finally, the variance is suitable and desirable as it results in a new detached dwelling through infill development and maintains residential use of the property. It also better supports the needs of the current homeowners and their family and aligns with the PPS official plan and zoning bylaw. Next slide, please. So based on this, it is the opinion of QLand Planning and Design that the proposed minor variance constitutes good land use planning. Next slide, please. So before we go into questions and comments, if I could, I'd like to pass it over to the property owners, Ed and Sharon Bryant, who should be on the call, and they'd like to say a few words of their own as well.
Please proceed.
Thank you. Thank you, Chair and committee members. So we moved to Ottawa from abroad 10 years ago for a better and a safer life. Since then, we've really made Ottawa our home, including recently getting our Canadian citizenship. We intend to make Ottawa our home for the rest of our lives, and a big part of that is building our forever home on Huron Avenue. When we designed the house, we were very conscious of designing a house that fit with the character of the neighborhood, including having a front porch, a pitched roof, a traditional stone facade, and a setback garage. We believe that the cantilever option that is available without a minor variance is hugely inferior and doesn't fit with existing streetscape. We also made sure that the whole house complies with other city bylaws by not trying to reduce the rear, front, or side yard setbacks and staying within the height restriction for the neighborhood. When consulting with our neighbors, we only received positive support for the project, with many of our neighbors saying that they too would love to have a garage. A big part of the move to Huron is to reduce our carbon footprint by going down to 1 electric car from 2 gasoline cars. We still require 1 car to visit aging family outside of the city. And this is one of the big reasons we are seeking relief to build a garage. Storing an electric car inside significantly reduces electric consumption and extends the life of the batteries, which can be severely damaged by Ottawa's winter temperatures. This, combined with rising car crime in Ottawa, where cars are frequently stolen from people's driveways, and the fact that our own car was already broken into on our Huron driveway, makes the garage, in our mind, a basic necessity. We're big supporters of the local community, including owning a business headquartered in Westboro and employing 8 people who live in the city. Our 2 kids are also firmly laying down roots in the neighborhood, including our teenage daughter that is already attending Nepean High School. We love Ottawa, and we hope you can support this minor variance.
Thank you, Mr. Bryant. Can we hear from the planning department, please? Because I know they object to this application.
Thank you, Mr. Chair. Staff object to the proposed variance as we are of the opinion that it deviates from the intent of the streetscape character analysis provisions. The streetscape character analysis is an objective count of building elements on the site, and they're intended to encourage development to maintain the character with the existing homes on the street. There are no lots in the scope of analysis that have front-facing attached garages, and therefore we believe that the proposed front-facing attached garage deviates from the intent of the official plan and zoning bylaw in this respect.
And for our information, the streetscape character analysis looked at how many properties and where?
That looked at 21 lots within the immediate 21 lots surrounding the subject site on Huron Avenue.
So these other 21 lots are all houses, or all homes, existing homes on Huron Avenue.
Exactly.
And there is not one front-facing garage in any of those.
Not within the 21 lot analysis.
Okay. Any questions or comments from the members of the panel? You've heard, Mr. Sir, you've heard from the department that they object, and there is no other home on this block that's within the study area that has a front-facing garage. So
Yeah, we have heard that, but and as I sort of articulated in my presentation, there are homes that are in the area, and not only on the area, but also right on Huron that do have front-facing attached garages. Some of them are even double garages. So there is some precedent in the neighborhood, and I do think that the SCA might have that objective count, but from what we're hearing from neighbors, this they feel that this is something that is in character, and they know this area better than the department could, or better than we could. So I do think I can put the slide up and show you the image as well if you'd like to take a look, but there are quite a few number of front-facing attached garages that are in the neighborhood, and frankly, I think that does show a pretty strong character as well.
all right, Ms. McLean.
Thank you, Mr. Chair. How far is the garage set back from the front wall?
So it's set back 0.6 meters, which aligns with the zoning requirement.
And if you were not to put a garage door on, are you allowed to park, or do you have to be open on the two sides for the cantilevered area?
So if you don't have the garage door, you would have to take out, basically you'd have to provide it. As far as I understand, it would essentially be the cantilever option, where it's just open on two sides, basically. And then at that point, it loses a lot of the function of the garage, a lot of the aesthetic benefits of the garage, but it's effectively doing the same thing. So
I think the difficulty is that the bylaw, as it stands, prohibits this front-facing garage as part of the streetscape character. And when you say in your letter that this building contributes to that, do you have any contextual streetscape that you could show us?
I think there should be some in the presentation. I'll defer to my colleague Christine on that.
Thank you.
Ms. McQuaig.
Hi, members of the committee. So as the context map did show, there are front-facing garages already on Huron within this immediate block. And further, when the process for the infill provisions were being developed, the intent of the provisions and negotiations that took place when they went to the Ontario Municipal Board at the time was generally to just prevent bad design and snout-nosed garages. And this was the process that sort of ended up being decided upon to do that. So long as the community, and the community was very much involved in that process at the time. And it's sort of their position in this particular neighborhood that they prefer the front-facing garage over the cantilever design, because the cantilever design, when we discuss streetscape character, it does not fit within that streetscape character. It ensures that the vehicle will always be visible, which is one of the things that the streetscape character review was generally hoping to avoid, is to remove presence of vehicles and other items that are not to be seen, or that generally from the streetscape you would not want to see, such as garbage and refuse and recycling. And so the garage accomplishes that. It's more in character than the cantilever option. There are not examples of cantilever options within this block, but there are examples of front-facing garages. In the planning rationale, and I believe in the presentation, I'd have to grab the slide, but there are, as Arjun noted and provide images, there are examples of those front-facing garages on Huron already. They're just not within the SCA scope.
Yeah, I think it would be helpful to have a streetscape, a contextual streetscape of the photographs along the houses. Did you consider a laneway to the back for a garage? And what would you lose if you had to do that?
Through you, Mr. Chair, the site is narrow enough, and in speaking with the architect, I know that the program for this dwelling is already quite tight, and I don't think the site would be developable with a lane towards the back. I'm 100% confident that that wouldn't be feasible.
Okay, thank you.
Mr. Wildman.
Thank you, Chair, and thank you, Ms. McQuaig. That was helpful, just some of the additional context for me. I've been sort of on the fence on this one. Anyone who follows this committee knows I don't think I've ever voted in favor of supporting the streetscape character analysis, although on this one I was struggling on this one a little bit. I did see some of the images that were there, and your commentary about the cantilever design not being within context of the area as well, I think is a little more helpful for me. And my real comment was, could I see a couple more images? I looked at them while you were speaking. I'm comfortable, Mr. Chair, supporting this request in your hands as to whether you wish to go into reserve or not. Thank you very much.
Mr. Wildman? Or not Mr. Wildman, Mr. Wilder.
I guess I'm torn on this one as well. I mean, we're so close to, the argument that we're so close to the transitway and the like compared to other properties we've had to consider. I mean, it's really a stone's throw away in terms of walking distance to public transportation. On the other hand, I appreciate the fact that, in a way, the argument, and I do support the notion of, the argument has been put forward that this is for an electric vehicle. I trust that is in fact the case, and that I'm aware of, the climate on such vehicles and the like. Just a neighbor up the street in the same situation by me. So I guess I'm not sure if we should reserve on this, Mr. Chair.
I don't think it's necessary to you, Mr. Wilder.
No, I guess I'm leaning towards supporting the application, the same as Member Wildman. So we'll see how the other members feel.
Ms. Oakeshott?
Thank you, Mr. Chair. While I'm sympathetic to the desire for the garage, I have to focus in on the fact that there are actually 0 representations in this area for front-facing garages, and it clearly goes against the grain of the intent of the SCA analysis. So I am leaning towards not supporting this at this time. Otherwise, in my view, I would have to vote the same in the future for any other front-facing garage if I'm going to accept it with a 0 baseline on the SCA analysis in this case.
Ms. McLean?
Thank you, Mr. Chair. I'm going to support the application.
Yeah. As am I. So is that a no, Ms. Oakeshott?
Yes. Yes, it's a no.
Yes, it's a no. All right. And Mr. Wildman, you're in support? All right. All in favor of the application as presented? Your application is approved with 1 dissent. Thank you very much. Good luck with your project.
Thank you.
Thank you.
Next application on the agenda is item 3, 284 Dover Court Avenue. And this is an application to permit an increased building height for an existing long semi-detached dwelling. And this increased building height, quite frankly, is the result of an error, apparently. The agent for this application is Mr. Hume.
Good afternoon, Mr. Chairman, members of committee.
Mr. Hume, before we begin, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I do, Mr. Chairman.
Okay. Simple question, Mr. Hume. How did this happen?
Good question.
I need a good answer.
Well, I've got one. I've got one for you because I know you're not the committee of forgiveness. You're the committee of adjustment. I've heard that before. This long semi was constructed in accordance with the plans approved by the city of Ottawa. So The applicant submitted his plans to Building Code Services. They were reviewed. They were stamped. He took those plans away. He gave them to his civil contractor and his framing contractor. And the building that you see before you was constructed in accordance with both of those plans. However, unbeknownst to, and you'll have to excuse the typographic error. This is the long semi, the front of the long semi. If you could go to the next slide. The plans had one minor error on them when they were approved. And that is the elevation of the first floor. So they were submitted, approved, and no one caught the slight variation on the two plans. So the civil contractor moved forward with the foundation and the servicing documents, built according to the plan, created the foundation walls according to the plan, and in came the framing contractor, and he constructed those two in accordance with the plans that he had. And at the end of the day, when the height was surveyed, was found to be slightly higher than required for a pitched roof such as is proposed. There was so this is a bona fide minor error in the plans that weren't caught during the internal review by the applicant, nor the review by the city planners. And it came as quite a surprise to the owner that the survey was, the height survey was 7.8 inches higher than is allowed. So that's how it occurred. But be that as it may, there are the committee, in understanding how this occurs, still has to understand the planning context in creating or in approving a minor variance. So when you look at it, I should note on the existing plans that if this were a flat roof, we would most likely be conforming to the height limit. So the issue is in the midpoint of the peaked roof, which is really an empty space. It's not a habitable space in this case. So any approval by the committee would not increase, for example, the height of the windows or any of the other issues related to the building. But we can go to the next slide to give you some planning context. So this is Dover Court Avenue. 284 is to the south in the middle, just below the M in mature. And as you can see, it has an 8-meter height limit along that height. Interestingly, the other side is an R3R zone with a height limit of 8.5 meters. And what that indicates is that you're not going to see large, this is not going to be a large variation when you look at the streetscape. And we've given you a picture directly across the street where you see a building of similar stature to what you would see with when you look at the building at 284 Dover Court. So if you want to just go to the next slide. These are the images both to the west. It's two semis and a single flat roof. We didn't do a height calculation, but we would assume that these would be about 8 meters in height. Typically, flat roofs are used to achieve a building form under a maximum building form under the height limit. And the two pictures next to you are the neighbors to the west, which is a small, I would say, story and a half property. So if you want to go to the next slide, when you look at the foretest of the Planning Act, is the variance minor? You're not going to notice in adjusting the roof line, if you were able to, would that noticeably change the building in its context with the streetscape? And actually, it wouldn't, because the first floor windows and the second floor windows would be in relatively the same position. And so it's not going to create increased impacts when you look at the streetscape or when you look at the neighboring properties. So it is, in that context, relatively minor. Is it desirable? A long semi is permitted in this area, and the variance doesn't place the building outside of the context of what is allowed in the streetscape, especially across when you look across the street. The general intent and purpose of the zoning bylaw, the height limits in the zoning bylaw are designed to create appropriate heights in context with their neighborhoods, and ensure that you're not getting sort of streetscapes that are I want to say out of whack, but out of context and jarring in their approach. You would not know, in reducing this the 20 centimeters, it's not going to have a noticeable impact, or it's not going to have any impact on the streetscape, because it is going to be almost impossible to know. So really, the general intent and purpose of the zoning bylaw with respect to height increases is maintained. And fourth, the site is designated general urban area, and construction of a long semi is consistent with the strategic direction of the plans. This does have secondary dwelling units, and at this point it is fully tenanted. There are people living in the two families, and two professionals are now living at the property. So it is clearly meets the intent of the official plan with respect to intensification and expectations. So that's.
Okay. All right. Thank you, Mr. Hume. Ms. Linker, I'll ask you the same question that I asked Mr. Hume at the beginning of his presentation. How did this happen?
Thank you, Mr. Chair. I have the same understanding as Mr. Hume, that this was reviewed at the building permit stage, and from my understanding, this discrepancy between the two plans, the grading plan and the elevations, wasn't caught during that review period, and it was approved for a building permit.
Okay. Mr. Wildman, do you have any comments regarding this?
Well, I'm glad I'm still not the manager responsible for this, but that would be my first comment. But I guess I can see two errors were made here. Two consultants were working on two sets of different drawings, and something was missed. And then when it gets in for its internal review, the grading reviewer looks at his plan, and the building reviewer looks at their plan, and somewhere that should have probably been cross-referenced didn't happen. So I think there's enough blame to go around, and I think we're really talking about how do we deal with this now. I think it's safe to say that the building will not be coming down. So how do we do something that's appropriate here? Under the circumstances, I'm always concerned, and I think as Mr. Hume probably would appreciate, given his experience in the planning field as well, of setting some sort of a perception that it's okay to build and then come in for an exemption later. And that's certainly not what we would want to do. And certainly if this committee were inclined to approve this variance based on the 4 tests that Mr. Hume went through and the explanation he gave us, I think this committee should be saying this is certainly not something that is precedent setting for us, and likely that it should be tied to the life of the building as well, so that if for some strange reason the building comes down, we're back to whatever the zoning in place should be. So I it's a tough one. It's an error. I think it's an error on a couple of fronts. And now we have to manage that error appropriately. So from my point of view, if the committee were inclined to support, I think that condition should apply for the life of the building. Thank you, Mr. Chair.
Thank you, Mr. Wilder. Mr. Wilder?
Thank you, Mr. Hume. I guess you're aware that the abutting property owner at 285 Dovercourt, the one across the street, sorry, did a very comprehensive calculation where he's suggesting that it's a change from rather than from 7.99 to 8.42 as opposed to 8.2. Are you aware of this?
I am, Mr. Wilder. So,
and go ahead. Yeah.
So so the height certificate that was surveyed by Stantec uses finished grade, uses the average grades as they exist after construction. So that's where you generate your 8.2, your exceedance of the height limit of 8.2. So in my understanding that in talking to the owner, the grades were different when the original building was surveyed. So the survey pre-construction and post-construction.
Thank you.
Thank you, Mr. Hume. One of the neighbors, I believe, wishes to speak to this. Ms. Morris? Can't hear
you. Hi, have I turned it on now?
Yep. And your address is 282 Dovercourt?
Yes, I'm the next door neighbor in what they called the story and a half, right beside the new build at 284.
All right, please proceed.
My concerns are this. The plans that were submitted are not in vibe with the building that stands there. We do not have a long semi beside us. We have a 4-unit rental. There are 4 separate people in the building. They are all renting. There is no owner. I do not know how the property is divided to be called a long semi. We have never seen that one side is owned by one person and the other side owned by another. It is in fact 4 rental units. I am not sure where the 8.2 meter begins or ends. I'm not sure where the grade begins or ends. I do know that the entire time the building was being built, the builder, Nemare, changed the grade constantly, kept adding retaining walls in, kept coming up and up. We now have a retaining wall next to us that was never there before. The original grade got changed. I'm not sure where that all comes from. I want you to note too that the plans that were submitted to you have a front stairway angled differently than the one that's actually built. It has about, 5 steps on it. The front stairway that's actually there has 9 steps up to it. Your submission, your blueprints you got submitted do not show that the east side, let me just make sure I'm getting this right, it's the west side, has actually now got 2 doors in it, very much elevated grade to get up to those 2 doors. Those residents have to walk up quite a way. There are 2 main entrances there on that side. The plans you were submitted do not show that the back of the house, which is facing south, has in fact got an elevated front or main door. There's at least 6 steps leading up to that level. So one of my concerns is transparency here. The fact that the prints I'm looking at don't match what's beside me really concerns me. So I'm not sure where you go from here. I'm not an advocate for tearing down a building. However, I have lost a lot of my natural light. And if this building is in fact only 8.2, well, then I'm not that concerned. But I'm really curious to how they got that 8.2, because it doesn't match the build that's beside us compared to the blueprints you were submitted and that the city originally okayed. So if the city is saying, well, somewhere we made an error, we okayed that, I'm questioning it saying, did you? Because what I see on paper isn't what's beside me. So those are some of my main concerns. My concern is also their grade, their driveway grade, which was for 36 years, even with our driveway grade, went up. All the water started to come over. They had to redo that driveway 2 to 3 times to stop the water running onto our property. So I'm not worried about the streetscape. I am worried about my loss of lighting. I am worried about the drainage. I'm really concerned about the fact that all the elevations they've shown you in the prints do not match what is actually there. So my concern is transparency and whether or not we really are looking at a 0.2 difference here. Thank you.
Thank you, Ms. Morris. Unfortunately, what we're dealing with here today is a height variance due to a mistake made between architectural drawings and a servicing drawing. However, if it is your opinion that what was built was not that was approved, then I would suggest that you contact Building Code Services and file a complaint.
I understood that's what I was doing now by coming to this meeting.
No,
is
we're only dealing with the height variance.
But how will I know? How do I know about the height? I'm not an architect. I can't get out there and measure.
We have the information in our hands, and we've had an explanation from Mr. Hume, and we've.
But the information in your hands is the same information I have because I asked for it all, and it's different than the build that's there.
So, Mr. Chairman, maybe I have a set of as-built plans that were submitted to the committee, and I'm just looking at them now. I'm happy to print them out in large scale and deliver them to Ms. Morris, and she can look at them and make a complaint to Building Code Services if that helps her, because I'm looking at the front steps and the as-built site plan, and I'm pretty confident that we've shown the steps correctly in the as-built documents that we provided to you, and I'm happy to provide to Ms. Morris.
So we don't have the as-built here. We neighbors who asked for the information, we don't have.
Mr. Hume has indicated that he will provide you with a set of the as-built plans.
I will.
So you can, quite frankly, as an abutting neighbor, you can take it from there.
Okay.
Ms. Morris. All right, Mr. Wildman.
Just a real quick question, Mr. Hume, I don't mind you answering, but or staff, but I just want to make sure that the as-built drawings are in staff's hands as well. And that's how they concluded the height variance that was necessary. Is that correct, Ms. Linker?
Yes, that's correct. I requested that prior to the hearing.
Okay, and just for the benefit of Ms. Morris, those plans are prepared by Ontario land surveyors. And so they are legal land surveyors who are licensed to do these types of plans. So I think it's safe to say that those plans, those as-built plans, as Mr. Hume referred to, once you see them, you'll see that they've been done by a professional who's qualified to do those. So thank you very much. Thank you.
Thank you. All right. Thank you, Mr. Hume. Thank you, Ms. Morris. Do we need to reserve on this application, ladies and gentlemen, or shall we decide?
I'm happy to vote now, Mr. Chair.
All right, Mr. Wilder.
Sorry. Yeah, I'll support the application. Mr. Hume, I would appreciate you making the point, Ms. Morris, if you're still on the line, that you somehow connect and at your earliest convenience, Mr. Hume, if you could drop off those as-built plans to her. And I just say to Ms. Morris, if you feel what you see in the as-built plans is not what in fact has been built, please contact our buildings branch. They will send a building inspector out to ensure that the staircase and others matters that you've raised are in fact as built. If they're not, there are avenues that the city will pursue in terms of addressing those issues. Thank you.
Okay.
So I will support the application.
So Sharon?
Yes, I support.
Thank you. Ms. McLean?
I'm in support, Mr. Chair, with the condition that it be tied to the life of the building.
Yeah, I think that's exactly what we'll do. We are also going to, I think in our decision, note that we are approving this reluctantly. And this is our approval of this is not to be considered precedent when matters like this are before us.
Well, Mr. Chairman, if this was a deliberate attempt, I wouldn't be here before you, and I would suggest that you should say no, which you have in other cases.
Yes.
So.
Yes, we have.
Yes.
All right. So with that condition suggested by Ms. McLean and accepted by the rest of us, all in favor of this application as provided with the condition added. Thank you. Application's approved.
Thank you, Mr. Chairman.
Okay. The next application we'll deal with is item 6 on the agenda, and that is 299 bracket 291 on bracket Carling Avenue. It's a consent application to subdivide the property into 4 parcels of land, 3 parcels for future development and 1 parcel for a city park. A lot addition to 360 Bell Street South and an easement for a future right-of-way for the city's bus rapid transit are also proposed. And the agent for this application is Mr. Santi. You're back.
I told you I'd be back.
Yeah. So before we begin, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I swear.
Okay, and I understand that this application follows on from a rezoning application which was approved by City Council in January.
That's correct, Mr. Chair.
Okay. All right. So, Mr. Santi, if you would like to just very briefly. explain.
Yes. So before I begin, Mr. Chair, my address is 2611 Queensview Drive, Suite 300. I am joined today by Catherine Constantine, Director of Real Estate from Canada Lands Company. We do, so I'll just maybe ask if Catherine would like to say good afternoon. And then we do have a presentation if the committee members need that. We're happy to do our joint presentation if needed.
I don't think we need a presentation. Do we have any questions for the applicant, ladies and gentlemen? Note that there are 5 conditions. Southwest 5x5 meter corner site triangle is a requirement. A southeast 5x5 again corner site triangle required.
Yes.
Road widenings are also required. A development agreement. If you could explain the development agreement to the committee.
Yes, Mr. Chair, I will turn it over to Catherine to explain more about the development agreement. I can say that CLC has reviewed city staff's report and the conditions and has no concerns with the conditions as laid out in the staff report. So I'll turn over to Catherine to explain the development agreement, which is underway between CLC and the city.
Okay, thank you.
Good afternoon. So yes, following the approved rezoning with the holding provisions, we have circulated a draft development agreement to the City of Ottawa for comment. And the development agreement outlines the obligations of which we'll be fulfilling as part of the future development of the site as they relate to the construction and future conveyance of the public park, privately owned public space, 15% affordable housing contribution, which will be made. So yes, we are in the process and hope to be settling that with the City of Ottawa shortly.
Okay, thank you. And the fifth condition, I believe, was a registerable legal description is needed of the property by the city.
Yes, Mr. Chair. So the, as I mentioned, all those conditions will be fulfilled. Stantec has prepared the draft reference plan that was submitted with the applications, and the legal description will be carried out as clearing those conditions as part of the consent approval.
And the committee is suggesting that a further condition be applied, and that's that a one-time conveyance condition for lot line adjustment.
So, Mr. Chair, the lot line adjustment would be a one-time conveyance. It is to correct, it's a technical correction that is being sought through the lot addition. So no issue there. Thank you.
So we'll add that. Okay. Any questions or comments from the members of the panel? All in favor of this consent application? Consent's approved. Thank you.
Thank you very much. Have a nice afternoon.
You too.
Thanks.
The next application we'll deal with today is item 4 on the agenda, 284 Churchill Avenue. And this is an application to permit reduced lot widths, reduced lot areas, and front-facing garages for a new semi-detached dwelling. This application, very similar application to this was before us this past June, and the committee dismissed the application. So, Mr. Gelkatzi, I believe, is the agent.
Yes, Mr. Chair, I'm here. Thank you.
Mr. Gelkatzi, before we begin, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I do swear.
All right.
I've also got a bit of an address change so my new address for me is 51 Rothwell Drive.
Okay. All right. So noted. We dealt with this property back in June. We dismissed the application. You are before us with the same variances.
Yes.
The question from us to you is, what's the difference in these applications, and are these significant changes, material changes in this application from the one that was before us and dismissed in June?
Yes, Mr. Chair, I believe we've shown that, or can show that they are significant changes. They've addressed the issues that were identified as part of the hearing, both by the committee and by the neighbors. As a result, when the client approached me to take on this file to the OLT, I said to them that I could not take the file to the OLT as it stood, that I would need to see some significant changes in it because I would not have supported the application either. In this case, I suggested these changes to the client. They agreed to these changes. And at that point, a lawyer was engaged to take the file to the OLT, which has been done. We've asked the OLT to adjourn it because my preference was to have the community make the decision on this file with the significant changes that we've made. I've had 3 meetings with the neighbors and the community association as part of this process. And I think we've come to a solution that really benefits both the community, the neighbors, the environment from that perspective, and also leads to a project that this committee could approve.
Before you begin your presentation, Mr. Gilcazzi, I'd like to hear from the planning department for a second. Mr. Hamilton, is he there? Mr. Hamilton, does the department consider this application a significant change from what was before us in June?
Thank you, Mr. Chair. For our purposes, we do. There have been a number of revisions to the front doors and the sloping of the front yard down to the front doors. So yes.
Okay. All right. Please proceed, Mr. Gilcazzi.
Chair, I'm sorry to interrupt. Just
sorry, Mr. Robin.
back to Mr. Hamilton for a second.
Certainly.
Mr. Hamilton, the reason we're asking for your opinion on whether it's significant or not is because we shouldn't be dealing with it if the application is not significantly different. And so whether some of the attributes of the file or the look are different is one thing, but is the request, what's before us, any significantly different? That's the question I think we're really looking for your input on.
I see. Through you, Mr. Chair, the variances are very similar, but the building design has changed. So to answer your question directly, the variances are essentially the same.
Thank you.
All right, Mr. Gilcazzi, please proceed.
Yes, I have a presentation. This just is a list, and I believe that you've reviewed this, but the list of changes that have been made are at the bottom and the issues addressed. So we've reduced the amount of retaining walls by 70%. We've reduced the height of retaining walls and removed fences. We've moved the front doors. So by changing the internal layout of the building, we've moved the front doors closer to the garages so that they're actually more visible from the street. We've also reduced the distance to the rear doors to the secondary dwelling unit by changing the interior layout of the building as well in that regard, and I'll show you those. We've also changed the slope on the driveways to bring the driveway slope much closer to what is permitted under the approach bylaws. In addition, we've adjusted the height of the front-facing garages and raised the entrances as well in the building by making an adjustment in the heights inside the building. So next slide, please. Next slide, please. This just illustrates the various elevations and the elevational changes that we've made. So the one thing that you'll note is that the length of the retaining walls and the distance to the doors at the rear and the grades have significantly changed. They're up by 2 feet to the back entrances and the front entrance, and up 1 foot for the garage door entrance. That's 0.3 meters and 0.6 meters. Next slide, please. This illustrates where these changes have taken place in the heights and the variances that we've made for inside the building as well as on the outside of the building. Next slide, please. Again, illustrating where these changes have been made to raise the building to a higher height in terms of the floor areas at the lower level. The overall height of the building has not changed. It has stayed identical. Next slide, please. This just illustrates the existing slopes of the driveways in the adjacent property and at the existing property. So all of these slopes exceed what's permitted under the approach bylaws private approach bylaw. Next slide, please. This just illustrates that we're staying within the height limit as required for the building. Next slide, please. Here's where we've done the 3D modeling to indicate how the slopes can be addressed. We did this using the geotechnical information from the survey. So these elevations reflect that information. Next slide, please. Here you can see the driveway coming in and the grade. The version is the same. The two shots are the same. One is not rendered a little bit. And this shows the height of the retaining walls, both existing and also where we're putting in the retaining walls and the sloped landscaping. Next slide, please. Same on the south side of the property. Next slide, please. This indicates we took the model and put it into Google Earth, and it's actually quite interesting because we geolocate all of our projects, both for sun shadowing studies and other things like that. You can see that the model actually fits very closely into the existing buildings. So you'll see that the actual locations of the buildings on the north and south of the property are clearly correctly modeled. Next slide, please. This is about the front yard garages permission minor variance. The neighborhood here actually, other than Churchill in this location, is predominantly complies with the SCA requirement that would permit a front-facing garage, both on this area of the neighborhood. Next slide, please. And on the north side of the property. I should say that I incorrectly noted that the co-op housing project that's to the east of the property has garages. It doesn't have garages, they are all carports. I apologize for that. So they aren't included in the SCA, and had that park and that co-housing project not been in the location, and we had a pattern of development that was closer to what's in the rest of the neighborhood in terms of front-facing garages or carports, then this property would comply fully with the SCA. Next slide, please. This shows the pattern of development. We've got numerous properties in the neighborhood that are of similar character in terms of severing into two properties as a semi-detached building. So very, very much consistent. Obviously, the property to the south is already a semi-detached with front-facing garages as well. Next slide, please. Here's the four tests. They're minor and desirable. They actually reflect fully the current character of the neighborhood. The way we've done the grading for natural grading, and as well the commitment on the part of the owner to work with the neighbors, both for fencing and for landscaping. So the owner has made a commitment and agreed that I will manage a meeting if the committee does approve this these variances. I will manage a meeting between the neighbors and the community and the developer to set out the method that communications will take place, and I will monitor that those communications take place. I know that there's been some difficulty in the early stages of this project, but I think this lends a little bit of security to the neighbors that the owner will follow through with the commitments that he's making as part of this. The general intent of the purpose of the bylaw is maintained to permit semi-detached dwellings. The intent for new infill property in the neighborhood. The intent of the official plan is also maintained, and the Planning Act supports intensification in the general residential areas. Thank you, Mr. Chair.
Thank you, Mr. Gilcozzi. Any questions from the panel regarding this application? Okay. We also have on the speakers list Ms. Lasso from the Westboro Beach Community Association. Are you there?
Yes, I am, Mr. Chair. Thank you.
And your address for the record, please.
Is 266 Ferndale Avenue.
All right, thank you. Please proceed.
Yes, we've been involved in communications with the agent for the developer, and there's been many, many discussions. And at this point, we will not oppose the variances requested, and we leave it in the very capable hands of the committee to make the final decisions. And just to note, we will keep, if this development does go through, we will keep a very careful eye on this. And if required, we will make other interventions as we go forward. But at this point, things are looking okay.
All right. Thank you, Ms. Lasso. And Mr. Trong, I believe at 288 Churchill Avenue.
Yes, hi, Mr. Chair.
Hi. Please proceed.
Yeah, so the developer has made some very positive changes to address our previous concern. My remaining concerns are only following. So first is the front-facing garage. I know the previous decision made by the committee was that the front-facing garage would not comply with the streetscape. So we'll let the committee decide whether they would agree to that at this point. The second would be around fencing, and the fencing should be on the property side, on the proposed property side instead of ours. And the third is landscaping. So I want to make sure that the landscaping of the adjacent slope is compliant and uphold so that it doesn't affect my driveway. And I appreciate that the developer is willing to work with us.
Regarding the fence, there are provisions that determine where a fence is located, and they have to be located inside the property line.
Okay.
And as far as landscaping is concerned, the applicant will have to submit a drainage and grading plan to the satisfaction of the city before any building permit is approved. And I would suggest that you talk to the applicant and have them provide you with a copy of the drainage and grading plan that they're going to submit to the city so that you can review it. But that will get any problems should be picked up at that point in the process.
Okay, thank you, Mr. Chair.
All right. And we also have Ms. Maureen Dugan, I believe, who is at 290 Churchill on the speakers list. Is she there? Can't hear you.
Thank you, Mr. Chair. I've unmuted. So good afternoon, and good afternoon, Mr. Chair and the committee. And we wanted to say that we have also seen many changes to the proposed plan, given the consultations which have happened. And in many cases, they do meet our original concerns, particularly with respect to retaining the tree and reducing the height of the retaining walls. That was very important for us. And we agree with the comments from the Westboro Community Association and from our neighbor Tran Trong. We're gonna have to leave it to the city and to the committee to decide whether the design as proposed right now includes significant enough changes to be approved, given the minutes and the decision that was taken on June the 10th.
Thank you, Ms. Dugan. Any comments, questions, Ms. McLean?
Thank you, Mr. Chair. Just to Mr. Jelkotsky, I'm just still concerned about the landscaped island that's being created for the city tree. And just wondering why you can't maintain the driveway slopes upwards, which I think is fairly prevalent in the neighboring properties. What do you lose from having to lower the driveways?
Mr. Jelkotsky?
Yes, through you, Mr. Chair. The problem here isn't so much what we lose, it's more the problem of the private approach bylaw. So there's a maximum slope that's permitted in the private approach bylaw. There are a higher slope that's permitted for existing circumstances, but this is not an existing circumstance, this is new. So the slope limit is there's two mentions of it in the bylaw, one in the private approach bylaw and one in the bylaw, in the zoning bylaw itself. And one is at 6% and the other one is at 8%. We're at 6% slope. The thing about, and this is a discussion that we had at the community as well, the thing about the secondary dwelling unit is that it is an at-grade approach, and it does make that unit potentially accessible for somebody as a secondary dwelling unit. So that's why we would prefer, and as we're required, to have a slope that is as low as we could possibly get it, but still at the same time trying to reduce the number of retaining walls and create vegetated slopes instead of creating these kinds of retaining walls. So it's actually quite open. If you look at the plans, you'll also note that when you go from the tree towards the west, it is all sloped down to the entrance now. It's the grade has been changed as such that there aren't retaining walls around the entrance as well anymore. It's all going to be naturalized and a natural slope.
So is it because you're trying to introduce secondary dwelling units that we have to go to, you have to go to this extent of putting the driveways where they're proposed and creating that island out front?
Through you, Mr. Chair, no, Ms. McLean. The requirement is the bylaw. So we'd have to seek variances from the bylaw to have a steeper driveway, on top of the fact that we live in a northern climate where steeper driveways of this character are not as helpful. So I'm trying to kill two birds with one stone. I'm a social sustainability advocate from my perspective, and I would prefer to see more dwelling units available that are accessible and otherwise. But on top of that, I'm forced, without having to seek further variances, to two bylaws. And we have a tough time because we've done this, had discussions with the private approach people as well with regards to slopes. This is a requirement of those two bylaws, of the zoning bylaw and of the private approach bylaw. And I don't know, Ms. McLean, if you, through you, Mr. Chair, if you're aware that there's also an internal document that the city has for the design of private approaches, and that's also tries to limit this type of circumstance.
Okay, thank you.
Any other questions or comments from the members of the committee? All right. Final comments, Mr. Gelkotzi, since we've heard from the neighbors.
It was just something that came to mind, but now I've from the questions I've actually forgotten it. No, Mr. Chair.
Okay. The planning department has concerns regarding this application. Mr. Van Wyck, are you there, please? Oh, Mr. Hamilton, all right.
Thank you, Mr. Chair. Our concerns remain similar to the previous application about the introduction of garages where the SCA does not permit them. The SCA is intended to be a quantitative analysis of the parking elements that are in the neighborhood. We do not see front-facing attached garages being a dominant element on this street. So we do think that including them in this proposal does deviate from the official plan and zoning policies and provisions.
So the department is objecting to this design element?
We have concerns about the introduction and the impact to the SCA, not necessarily opposing.
Okay, thank you, Mr. Hamilton. All right.
Thank you.
We have a number of requested conditions, Mr. Gelkotzi, and just to make sure that you're aware of them. The development agreement, which includes a tree information report update. You're aware of that. The provision of securities for 3 years as well. And the committee has a question. Given the June dismissal was appealed and is before the Ontario Land Tribunal, we were considering imposing a condition that says that if should we approve this application, that your applicant will appeal or withdraw the appeal to the OLT in its entirety, the current one that's in there. That seemed to be necessary.
Yes, Mr. Chair, absolutely. That condition, I should have probably written something to that effect. We would be withdrawing the appeal, obviously.
Okay. I think with that, I think we'll reserve on this application. We have some further discussions on the evidence presented to it. And,
I just thought of the one thing that I was going to mention. We did seek outside advice at the same time that we spoke with Mr. Hamilton about whether the changes that we were proposing were significant enough for you to hear the application with Botan Brian Casagrande. So we got an independent opinion from that perspective. But
all right. Thank you, Mr. Giacozzi. Like I said, we're going to reserve this on this application, and you'll receive our notice of decision within 10 days. Thank you very much.
Thank you, Mr. Chair.
Thank you. I believe that concludes the agenda for this hearing of the Committee of Adjustment for the City of Ottawa. Well, thanks to everyone for participating. We will now go to our reserve hearing. Thank you. Bye-bye.
Once again.